challenges to the rule of law in the European Union, and what does this all mean, and what can we do about the observance of the rule of law and compliance with the rule of law. Now, the rule of law is a word that is almost like apple pie or motherhood. It's interpreted or taken for granted, I should say, by a lot of people, but it is not necessarily understood the same way. I'm going to talk as the first speaker about what the rule of law means and what is the common denominator for this term around which we can rally and which we can support and ensure that we're not going to be engaged in endless definitional debates. The rule of law, according to the European Union, according to the United Nations, according to the North Atlantic Council, according to the Canadian Charter of Rights, is the centerpiece, the cornerstone of a democratic community. So it's something very important. Now, the paradox that we're going to be confronting in this panel is that if the rule of law is the centerpiece of democracy, the cornerstone of democracy, and if Hungary is in breach of the rule of law, then what is she doing within the European Union? Why is she there? If the European Union considers the rule of law as a prerequisite for membership, how come Hungary is in? When people are suggesting, and more people and more reputable international organizations, that this country is in breach of the rule of law. It's a paradox. We're going to confront this paradox. We're going to ask whether the answer resides in the unusual ability of the Hungarian government to disguise its misconduct. Is it perhaps the other answer is that perhaps Hungary is not in breach of the rule of law, that in fact she's doing nothing wrong, and the whole sonata, the whole discourse about Hungary's misconduct is purely based on misinterpretations, non-factual information, driven perhaps by political ill will, driven by the ill will of opponents to the current Hungarian regime. That's another possible answer. We're going to confront that. We're going to look at that possibility. The third possibility for why Hungary, if she is breaking the rule of law, is that perhaps the European Union is unable to practice what it preaches, that the European Union is unable to keep its members who are out of line in line. We're going to look at that. That's colleague Kim Lynn Shepley is going to be focusing particularly on that aspect of the question. So this promises to be an interesting session. We're going to be talking about a very important subject matter that is central to the global democratic community. Now, I'd like to, in my preliminary remarks here, reassure all of you who are here, and some of you who know me as a very outspoken critic of the current Hungarian government, and I'd like to reassure all of those people who eventually will be watching us on YouTube, that contrary to my usual performance, I'm not going to say anything bad about the Hungarian government. I'm going to change roles. I'm not going to say anything bad about the Orbán regime. I'm not going to make any accusations about its conduct. I'm going to be instead walking on a very narrow but not unhazardous path, the path that I would call the path of righteousness. Why not? So I'm going to walk on that path. My job in this panel is to stretch a thin line between ancient Greece specifically Aristotle, and this podium, and this panel, to talk about a path that first Aristotle walked on, and then such thinkers as John Locke, as John Rawls, as Jürgen Habermas, as Immanuel Kant, and many, many others have walked, driven by nothing but the desire to create a recipe, to create a formula which would enable citizens in a community to work together for mutual understanding, to be understood and to understand, to create circumstances whereby they could, through friendship, through communications, through fairness, create a world for themselves that would be free of destructive and unruly behavior. So that's the path that I'm going to be laying out for you. What is this path? What are its key benchmarks? What are the steps along this path that states and governments like Hungary should be walking in order to be able to call themselves as respectful of the rule of law? What is it that is demanded for travel on this path of righteousness, the path that leads us to the rule of law, respect for others, mutual understanding, and communal life that is built for the purposes of promoting respect for our fellow human beings. So this is what my focus on this panel is. This is what I'm going to be doing, and I'm just looking at my notes if there's by chance anything else that I've forgotten to tell you about, but I think that's it. So this is by way of introduction. I have roughly 20 minutes, I think, to do this and sketch out this path and find out where we are with this with this roadmap, and then it will be up to my colleagues, András Göllner, to tell us what are the Hungarian cooks doing with this recipe. No, I didn't say crooks, cooks. Okay, what's happening in the Hungarian kitchen? András Göllner will talk about that, and then Kim Shepley is going to be talking about what happens if the cooks are messing up the stew, messing up the recipe. What can the community within which they are members, what can the community do about it? What can the European Union do about it? What can the North Atlantic community do about it? And what can the Canadian government do about it? Okay, so that's the structure of this. So let's begin by the first slide, which basically shares with you the notion that the rule of law has played for a very, very long time a pivotal role in the definition of democracy and civil society, if you will. The quotation is from John Locke, a very well-known philosopher, who says, wherever law ends, tyranny begins. Boom. This is the simplest, shortest, briefest expression of the importance of the rule of law to freedom and democracy. Doesn't get us past first stage, doesn't get us to the second stage. Ever since John Locke, ever since Aristotle, the definition of battle has been going on. What exactly does this very important prerequisite mean? What does it consist of? What are its legs, arms, and other appendages? There's another statement that's more recent, and it comes from the European Commission, which is the highest decision-making authority or body within the European Union. And the European Commission, in its March declaration, states, and you can read from the screen, that the rule of law is the backbone of any modern constitutional democracy. Respect for the rule of law, or obedience to the rule of law, is a precondition for EU membership. Respect for the rule of law is a precondition or precondition, sorry about my accentual slippages here, a precondition for the guarantee of all the people who compose the European Union guarantee to member states, member people of the European Union, that their freedom, their security will be protected and preserved. So it's a fundamental value, it's a cornerstone value according to the interpretation of the European Union. It's a very serious matter, but again, we have no breakdown of just what is the rule of law, this important cornerstone. So let's try and take this a little bit further. And I gave the title to this slide, what's in a name? What's in the name of the rule of law? And we find when we're looking for the definition that it's a bit of a nightmare. So many people have tried to define it, tried to pin it down, tried to give it primary characteristics, its main attributes, and the search goes on and on. Just not very long time ago, the International Bar Association expended a great deal of energy to finally summarize it, encapsulate it, and there's still debate. I wanted to give you a little sense with this slide of the kind of cynical, perhaps, statements or sentiments articulated about the rule of law by some very serious people, by very prominent jurists. One of them is Judith Sklar, a Canadian, a person who happened to be also the former president of the American Political Science Association, who stated in writing, and not in an idle chatter at the cocktail party, that the rule of law has become a term that is almost meaningless by now, because it's used in so many different ways. It has become a devalued coin. Another professor, Brian Tamanaha, stated a similar sentiment and said that there's so many divergent interpretations, so many contrasting interpretations, that it's almost a meaningless term. And Professor Jeremy Weldon, who's a very well-known professor at Oxford and New York and various other places, compared the term to hooray for our side. Everybody uses it, just like the term public interest, to justify their actions. And they give themselves some kind of legitimacy. So there's a very significant body of professional juridical opinion that considers the rule of law, because of its multiplicity of definitions, as having been devalued. We need to do something with this. We need to get to a point, and I hope I will be at the point in about 10 minutes from now, where we will have a consensus. So let's get into the clarification. Rule of law versus rule by law. There are many governments over time, through history, who have been confronted with the rhetoric of the importance of the rule of law, that it is necessary to gain legitimacy as a civilized democratic organization, a state government, and have positioned themselves as rule of law followers, yet ran autocratic, dictatorial, authoritarian regimes. Hitler's Germany is a case in point, Stalin's Russia is another case in point. There were elaborate laws, constitutions in both cases, defining what governments can do and what is the relationship between the rulers and the ruled, and what has to be observed in various domains of life. But these authoritarian societies were not rule of law societies, they were by law societies. What really, and in the most simplistic way, distinguishes rule of law from rule by law is, as I stated on this slide, under rule of law, you can sue the president, you can sue the first person in power, take him to court. We see this happening in the United States, where legislators, congressmen have tried to take the US president to court. You cannot take the president of Russia to court, because there you have not rule of law, but rule by law. And one of the rules under President Putin, when he was elected, one of the rules that was very quickly enacted is that you can't sue the president, you can't take him to court. So rule of law, rule by law, big difference. Authoritarian societies are often ruled by law, but they're not rule of law societies. I promise you that I wasn't going to criticize Viktor Orban, who's the Hungarian Prime Minister, but I wanted to give you just one little flavor of his position on this question of rule of law versus rule by law. In a speech last summer, he was speaking to a very, very large audience, talking about how he considers Russia and China as the role models for the new Hungary. Illiberal state model being the one that he favors. And he said that, could you imagine, he asked his audience, where I would be, what Hungary would be like if my fellow congressman could sue me? And he chuckled. And essentially, that was a rule by law statement. That was a statement coming down on the side of the rule by law position and running contrary to the rule of law position. So, what then? Let's go closer and zero in on this rule of law question. And what I'm going to be emphasizing here is a definition of the rule of law that I call a dynamic definition. Dynamic definition which tries to capture the essence or the meaning of the rule of law in motion, not as a statutory object, not as a freeze-shot photograph, where you can capture the image of a bird, for example, in flight, freeze it, and you can count how many feet it has, how many wings it has, what kind of a beak it has, and from which you can conclude that this is a bird. But what you cannot conclude from that picture is what the bird is up to. Where is it going? What's it doing? What's driving it? What's its intention? Is it a bird of prey? Is it a predator? Or is it simply a peaceful, seed-eating creature? So we need a dynamic definition of the rule of law. This is what I'm arguing for. Definition which looks at the rule of law in relationship to three things. Three things. One, parliamentary sovereignty. How the rule of law and parliamentary sovereignty live together as a couple. How does the rule of law live together with justice, and how does the rule of law live together with constitutionalism? And this is what I'm going to be now focusing on. Parliamentary sovereignty. What does this mean, and how does it relate to the rule of law? Parliamentary sovereignty is the concept of governance which defines first and foremost the British way of government. It's a system which argues that the ultimate arbitrator, the ultimate crafter of the law is Parliament. It is not the judiciary, it's not the judges who have the final say, but parliamentary deputies about who gets what, when, and how. Okay? So that's the British system. It's based on the fusion of power principle, rather than the separation of power principle. The executive branch of government, the legislative branch of government sit in one room, which is called the legislature, and they work together. Fusion of power. It's a system of government where there's no superior power to the legislature. In the United States, the Supreme Court is superior to the president, superior to the Congress, not in Britain. Parliament is supreme. In such situations where Parliament is supreme, the rule of law is always potentially in danger, always a threat. Doesn't mean that the threat is acted upon, but there is a fragile relationship. And in order to make sure that that fragility doesn't break down, that parliamentary sovereignty doesn't breach the relationship and turn the relationship into a dominant relationship based on abuse, the British have developed a whole bunch of safety mechanisms. That's the best way of saying it. The establishment of parliamentary law, which emphasizes scrutinization, the key word, scrutinization of legal proposals, bills, through parliamentary law within Parliament, and scrutinization through civil society, the mass media, pressure groups, non-governmental organizations, and other bodies outside of Parliament to ensure that whatever is enacted by the legislature is going to be in the public interest, is going to be in the interest of the people. So the British, through their practices, recognize that if you're going to have parliamentary sovereignty you've got to have a very elaborate system of public scrutinization, because otherwise the rule of law will become abused. Okay? So parliamentary sovereignty is fine. Parliamentary sovereignty is used, for example, by the Orbán regime as its last argument, escape route against attacks which suggest that they are abusing, the Hungarian parliament is abusing the rule of law. They say, look at Britain. Parliament can do whatever it wants. This is what we're doing. But what Mr. Orbán doesn't tell us, and his officials don't tell us, is that in Britain there's a whole mechanism to make sure that the rule of law is not going to be abused. In Hungary, these mechanisms are working in a very problematical fashion. Second relationship, constitutionalism. Constitutionalism is a principle, an idea that again goes back to the ancient Greeks. And what is the key feature of constitutionalism is that you have to have a line, you have to draw a line, a limit beyond which governments can't go. You cannot use authority to get their way. The Constitution can be written down in a formal document, or it can be unwritten. There's discussions about which system is better, the written system or the unwritten system, where a sovereign parliament decides. But the bottom line under constitutionalism, or the most important thing to know about constitutionalism, is that whenever there is no room given, either through a written constitution or through formal scrutinization, if there's no formal scrutinization allowed, or if that scrutinization is restricted, the rule of law and constitutionalism, the principle of constitutionalism, is breached, is threatened. If there's no scrutinization, if governments can willy-nilly change the fundamental law, then we have problems. How much time do I have? 10 more minutes? Fantastic. I might do it in 9, so good news. So whenever governments put limitations on scrutinization as far as constitutional change is concerned, we're in trouble, and the rule of law is threatened. So any legal system, as I put in this slide, that permits this kind of thing to happen isn't worth a thing, isn't worth the paper that it is written on. Any system that legally permits governments to limit scrutinization. Now, last point under constitutionalism that is important, and it's part of the Aristotelian and the Lockean theoretical construct, and applies to the present day, is that constitutions and fundamental laws, changes to those constitutions and fundamental laws of the land, which define the relationship between the rulers and the ruled, should be ultimately grounded in the people that compose the community. The entire community should be involved and empowered to participate in the crafting of the Constitution. Everybody should have a kick at the can in a disciplined fashion. The executive, the legislative branch, the judicial branch, within the legislative arena, as well as people outside, especially the legislative arena, those who elect representatives, the mass media, pressure groups, interest groups, and other people. So any kind of arrangement which parts from this principle of constitutional change being vested in the hands of the people, the sovereign people, any departure from that is a serious breach of rule of law practices. Constitutionalism is a central part, in my book and in many other books, of the rule of law equation. Last thing that I want to look at before I finally formalize this definition is justice and its relationship to the rule of law. Now, again, definitions of justice, attempts at defining what justice means go way back to 2,500 years, maybe a little bit longer than that. all kinds of people have taken a run at this task. I'm going to give you a formula or a formulation that I call an overlapping consensus. A consensus over the definition of justice, which the left and the right and the green political movement can rally around. You can be a Christian Democrat, a liberal Democrat, you can be a social Democrat, you can subscribe to it. So there is, in other words, an overlapping consensus about the meaning of justice. And I'm going to tell you what that is in a few brief sentences, because it is not that complicated. There are three key people to this arrival point, the overlapping consensus. Three key people who are related to this. One is Aristotle, the other one is John Rawls, and the third one is Jürgen Habermas. Aristotle, and I'm a little bit ashamed that I have to distill him to such an extent, but we're distilling, not alcohol, but concepts. Aristotle says, and drives the point through, that you can only have justice in a community where people desire it, where people want it, and where people are empowered to cultivate justice. It's a very fundamental thing. Rawls and Habermas begin with that starting point. You have to want justice, and people have to be empowered to cultivate it before you can talk about anything. Rawls and Habermas modernize the seed that Aristotle laid 2,500 years ago, which then lay hallow or fallow, whatever the right word is, for 2,000 years. And there were all kinds of different principles of justice operating in the world: divine right of kings, might is right, all kinds of things were used as definitions of justice. Kings rule by virtue of their relationship with God, and you can challenge them because the highest ordainer of justice is God himself or herself through kings who are sanctified by Rome in the Christian era. So what does John Rawls say? John Rawls said many things, but one of the core things that he pointed to with justice is the need for public reason, the need for dialogue, the need for discourse, rational reasoning through fearless speech about ends and means. And if you guarantee that, if you guarantee public reason to exist in a community, you're going to arrive at a just society. Jürgen Habermas takes this a little bit further. He talks about the importance of communicative action, that citizens in a community should ultimately engage each other through communications in order to understand each other and to be understood and to create mechanisms of conflict resolution. But what Habermas does that none of the justice theorists did, is that he also developed a system or a code of discourse, the rules of discourse, if you will, through which you can arrive at public reasoning. So Habermas and Rawls go very nicely together, although there are lots of disagreements between the two of them on all kinds of matters. But Habermas is very important because he not only establishes communicative action as a central core principle for democratic, civilized societies, but also provides a theory or a set of laws as to how discourse should be engaged in. And I'm going to just quickly flash this on, and I have 2 minutes, so it's not a victory, eh? It's 2 minutes. Yeah, all right, 2 minutes. I thought you said victory. Great. So these are the rules of discourse for Habermas. You have to have logical, semantic rules, norms governing procedure, and the rules guaranteeing against coercion, inequality, and repression. Since I only have 2 minutes, I'm going to just leave that there and go into my last 2 slides. So I only have 2 slides to come, and I can rest. So taking all of these things together, taking parliamentary sovereignty, constitutionalism, and justice, and blending it in to the rule of law, we can arrive at a dynamic definition which has 4 key components. One is legal certainty and constitutionalism, which means that governmental authority is based on publicly declared laws, which define the limits of government, are binding on governments, and which cannot be changed arbitrarily or in a one-sided manner. The second principle of the rule of law is public scrutinization and justice, which I have just described. Governments must guarantee and promote fearless speech, equal and informed participation of citizens in the political process, scrutinization, and political competitiveness. The third element is equality under the law. Everybody has to be treated equally under the rule of law. There cannot be exceptions. There cannot be ways out, little gates through which various preferred people go. And finally, the fourth key principle of the rule of law is judicial independence. The judiciary must be free from political control. These are the 4 key elements, and András Göllner, who is going to be following me, will describe how Hungarian political practice fits in with these dynamic definitional requirements. Here's a slide that I'm not going to go through, which is the European Union's own definition, which is very similar to what I have just laid out. The challenge for us in this panel was that we should come up with a concept of the rule of law that is globally conformist, that everybody can rally around it, that it's not something that a few eggheads, academics dreamt up and is out of line with the rest of the world. The definition that I've put together for you is in line with the European Union's own definition. So it conforms, but more importantly, what it also allows us to do is to calibrate what the rule of law means so that we can make meaningful, verifiable judgments about whether somebody's in compliance of the rule of law or breaking the rule of law. The instrument is very good for that. And I'm finished. Conclusion. The conclusion is that in any society where the governments limit political competition, encroach the principles of justice, exercise parliamentary sovereignty in a manner which limits scrutinization, and all of those variables which I listed as important, in societies such as those, we cannot talk about the existence of the rule of law, but the resistance to the rule of law. Now let's see whether Hungary is in that position or not. So thank you very much for paying attention to me.